folks, welcome to another episode of Hope House Presents. This is your host Ruby Naka. In this episode, we have 3 questions and a case study. Let's go right in. First question is, my husband is in the Indian military and we are currently based in Northeast, but we are from the South. Ours would be a step-parent adoption and we can only take a short leave to go home. I'm wondering which place I need to do my adoption from. First and foremost, I really want to take this opportunity to say thank you to your husband and to your entire family for your sacrifice to protect all of us in this country. If you look at the documents that you require to do stepchild's adoption, there is one document that says proof of residence. I'm assuming that you have an address for your base where you would be receiving communications. I'm pretty sure that you should be able to use that as a proof of address to begin your adoption at wherever you are located at. Because as you say that if you're coming for a very short duration of vacation, there is no guarantee about how long your adoption process is going to take, because the most lengthier part of your adoption would be the finalization of adoption in the court. That no one can assure you any kind of time frames. So what I suggest, first option would be to use your current base in Northeast as your proof of residence. Ask your husband to talk to his superiors and to see if he can use the base's address as a proof of residence to start your adoption. And if you have any kind of difficulty with the language, hire one translator to prepare the documents in the local language and to be able to communicate with people. That should be able to help you. But if you don't think that is going to be the solution that you can work with, what I suggest is, wherever you are from in the South, find the CWC's address and communication number and talk to them in advance and tell them that you would be coming to your place on such and such a date. You need a document declaring your child legally free for adoption so that you can take the adoption process forward in the court of law. And you can hire a lawyer who can take this process forward in the court even in your absence. What I mean is, he will do the pre-finalization process in the adoption in the court by filing the papers. But on the day of the finalization, you would be required to come before the judge. So please be aware that on that day, your husband has to take leave from his boss and be able to present in the court in the South so that your adoption process can be finalized. Our second question, I'm being asked by a prospective adoptive couple to write a testimonial for their adoption, and I'm wondering what I need to write in the document. Very interesting question. There are no guidelines for this in the CARA regulations of 2017. I will just say what I think is the right thing, and I will cover 4 points. First, you need to state what your relationship is to this couple. Are they your co-workers? Are they your relatives? How are they related to you to ask you to write a testimonial? You need to state that very clearly. Second thing, what you need to state is how good they are to each other as a couple. Are they loving couple, caring couple? They take care of their needs well. It has to be a very positive statement about their relationship to each other. And the third point I will say is, they as couple, how would they be able to care for the child to come? You might be wondering, how am I supposed to know? You may have seen them as couple in social gatherings and here and there where the children are there. How did they react to that situation? So, they're very loving towards children, they're very caring towards children, and you can even quote certain situations in a very generic form. You can say that when I was attending a wedding, there was 1-month-old baby, and the moment this couple saw this baby, they were so fond of this baby, they wouldn't leave her, they wanted to carry her. You know, in a very polite and professional way, you might want to state that incident to convey what you're trying to say. And the last thing I want to say is this: materially, how are they going to be able to care for this child? You may not know exactly what they have and what they don't have, and you're also not supposed to write specifics. But you could say, you know, they own a house, they are successful professionally. Those kind of statements can be used to state their material assets to care for this child. Next question is, I lost my husband when I was 7 months pregnant. I got remarried when my daughter was 2 and she is 5 now. I want to change her surname to my husband's because she is very close to him and I do not want her to know that she is adopted. Any advice? In my earlier videos, I have stated that there are 3 fundamental principles of adoption. The number 1 principle of adoption is that adoption ought to be done in the best interest of the child. No matter what the circumstances are, you always have to put your child in front of anything and do the adoption in her best interest and best interest alone. I want to share my own personal experience. In the year 2000, my wife and I were trying to adopt our first child, and we were asked to attend mandatory pre-adoption counseling. When we attended, I was of the view that I'm not going to tell my child about her adoption because she's going to be my daughter. Why should she know anything about adoption? But in that pre-adoption counseling, we met an adult adoptee who came and told her how her parents dealt with this scenario. She told us that she has grown up knowing about her adoption from a very young age and what that fact did to her. And she told us at the end, you will never be able to keep the fact of adoption as a secret. And it is not about keeping it as a secret, but when you start opening up, how do you open it up to the child? Do you present it in a positive light or negative light? If you present it in a positive light, child always will grow up very strong knowing that this is not something to be ashamed of. But if you present it in a negative light, child will grow up resenting it. And when the child grows up at an older age that she is adopted, she will begin to distrust you and she will begin to question what else are you keeping it as a secret. And that would be a slippery slope you will never be able to recover. Now we have reached the last part of our presentation. That's a case study. A 2-year-old adoptable girl child with special needs was referred by the Child Welfare Committee to a specialized adoption agency. But the agency refused to accept the child, quoting that no one would adopt her. Can they do that? And what recourse is there in a situation like that? You may recall from my earlier videos about 7 different kinds of institutions collectively known as childcare institutions under the JJ Act. For the sake of making it easier for you to understand, I'm going to list them one more time. Children's home, open shelter, specialized adoption agency, observation home, special home, place of safety, and fit facility. These are the 7 institutions known as collectively as childcare institutions in JJ Act. Section 41 states that any institution under the childcare institution category ought to be registered. Subsection 8 of section 41, the same section that talks about the registration. If you come down a little bit in the subsection 8, it very clearly states that any institution that is registered under this act is duty bound to admit children. So specialized adoption agency cannot refuse to admit children, quoting that nobody would adopt this child when the CWC is referring an adoptable child to them. The only exemption that the JJ Act allows for any childcare institution not to admit children is their capacity. If the children that are in their home has reached the capacity, and if CWC is referring a child, they are free to say that we don't have any more place and we cannot accept. But apart from that, as I said earlier, they're duty bound to admit children that are referred to them by the CWC. Another point I want to say is, in a situation like this, CWC can look around in their jurisdiction to see if they have any institutions that are recognized as a home for special needs children under subsection 2 of section 50. They could send the children there and give them linkages under the section 66 of JJ Act for adoption process to be continued by the specialized adoption agency. Now the last point I want to say is this: if in case CWC looked around, adoption agency is refusing to take a child, and they looked around and they do not have any designated children's home for children with special needs, what they can do is they can ask the SARA, that is State Adoption Resource Agency, to recognize a particular home under subsection 2 of section 50 of JJ Act and subrule, that is sub-regulation 4 of regulation 48 of adoption regulation of 2017, which also says that children that cannot be placed in adoption can be sent to a home that has specialized facilities, which is known as specialized institution, to be sent there so that the child can receive treatment and process of adoption can be continued. That's all the questions and case studies I have for today. If you like this video, please give me a like, share it widely, and comment on it. Most importantly, do not forget to subscribe to this channel so that you will continue to watch our Hope House presence. Till we meet again, goodbye.